Mama's in the living room watching Judge Judy. I'm in the kitchen eating leftover sushi, and she yells, "Oh, girl, you gotta hear this one." A man was arrested for running a theme park, and when they said, "Where's your license?" he said, "My dog ate it." Oh, you can't make this shit up. Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on her Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one." Mama loves to laugh at how absurd life is, says it's all a comedy and I'm her audience. And I love the way she makes fun of the world. She said, "You'll never guess what's with their girlfriend. It was a man who didn't get us out of the bed. He said, I've been through hell and now I need some help. You just can't make this shit up. You just can't make this shit up." Sometimes I wonder if life's just one big cosmic joke. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout. It's like she's on a Reddit, reading r/funny lawsuits, yelling from the couch. As she sips on a Prosecco, makes fun of all the weirdos, and then I hear her shout, "Girl, you gotta hear this one."
Hey everybody, how are we doing? Running a little bit late today because life. And FYI, if you're going to do a partner workout and you want to make sure that you're not going to be able to walk for a week, make sure that your partner is the owner of the gym, who is a beast. I love her dearly. She is the little's best friend, but being her partner is like stepping my game up to a level that I am not capable of. So I'm extremely tired. For good reason, but I am extremely tired. We are going to talk about the NIL lawsuit, arbitration, whatever people want to discuss it as. Some idiot blew me up in the comments saying that I didn't know what the fuck I was talking about, even though I was reading the document last time. So whatever the fuck you want to call it, that's what you can call it if that makes your little heart feel better. Anyway, before we get started, I mentioned this yesterday, but we do have to talk this channel and big picture. Big picture with this channel. So we are flipping the script starting on Monday. I am not streaming every day like I have been. We are changing things up a little bit. Starting next Monday, our streaming schedule, guaranteed streaming schedule, is going to be Tuesday, Thursday, and Friday, with Saturdays as a collaboration / bonus day, court coverage, anything like that. 3 days guaranteed. 4th day, if things come up or get busy. Let's discuss as to the why. I love reading documents. I love hanging out with you. I love this community. However, I'm building this for the long term. The reality of life right now is I have 2 YouTube channels. I am quote unquote a stay-at-home mom who works outside the house 2 to 3 days a week. 2 YouTube channels, and I'm training for a CrossFit competition. I take all of those roles seriously, mom being number 1. And with that being said, I also take my degree in occupational therapy, my certification in lymphedema, certified lymphedema therapist, and my certification in corrective exercise even more seriously than I take this channel. And I want to grow my second channel. And in order to grow my second channel, I kind of have to step back from this channel just a little bit. My evidence through motion, I didn't start that as a hobby. I want that to be my career. I am training people on Mondays. I am doing one-on-one face-to-face sessions with people on Mondays. So that and working outside the house for 5 hours on Monday nights. It's very mentally taxing to work up the research and everything that I need to do for this channel, while also making sure that I give 100% to each of my clients. So starting next week, we're kind of pulling back on this channel a little bit. I will still be streaming. We will still be doing everything that we like to do. However, I'm going to put more effort into the other channel because I would love that channel to explode. That's my baby. That is my career. And since COVID and everything that I saw working in a hospital with COVID, I am not ever going to be working in a hospital or traditional healthcare setting ever again. With that being said, I still have a degree. I still want to use my degree, and that's how I'm going to do it. Secondly, yes, right here. Heidel, thanks for posting it. So that is my link for the Tallow Truth. Y'all have known that I bought tallow, beef tallow skincare product just to try it out because I am trying to reduce the amount of chemicals that I use in my skincare. We have so many chemicals that may act as endocrine disruptors, and we are lathering that all over our bodies every day. And our skin is our largest organ. If y'all know me from the other channel, we've talked about that. However, I have become obsessed, absolutely obsessed with the Tallow Truth F-Balm skincare. And I don't have it right now. It's in my gym bag because I was using it as a callus repair after the gym today. So it is actually in my bathroom and I don't have it with me, which is sad because I'm like, I need it right now. That's why I was going through my purse because I was like, where is it? Where is it? Anyway, I am now affiliated with Tallow Truth. And if you click that link and use the discount code SQUID for 15% off. Yes. Do you link the discount in the description? You can use discount code SQUID and get 15% off. I'm obsessed with that. I use it from everything from a lip balm to an eye cream. It's helped with this little piece of, and I have such sensitive skin that I break out and or itch over everything. I have eczema. I itch all the time. You will see me itch, pick at my skin because it is that bad. However, this calms that. It's weird. Instead of having 50 ingredients, like my lip balm even has red dye in it. Why a lip balm needs red dye, I'm not sure. However, this has 3 ingredients: grass-fed beef, beef tallow, frankincense oil, and honey. And that's it. That's it. And I absolutely love it. I use it for everything. Mainly cuticle oil, calluses, and a lip balm. But yes, I do have a 15% discount code. Oh, yes, and their ads and testimonials are awesome. They are, if you are into the whole non-woke skincare, they are a Canadian-based company, and they are just Canadian farmers. And they just do what they do. And I absolutely love what they do. And I'm obsessed. So I asked for a discount code, and they said yes. There you go. Yes. Less government ingredients is better for you. Yeah. Yeah. And not to say that every skincare has ingredients that are bad for you. However, when you're compounding makeups, lotions, body washes, perfumes, everything on top of each other, it gets a little combined with what's in our food supply. We don't even need to go there right now. Just saying. So I did get a discount code, so y'all can try that. And some people that I know in this chat already use that product and love it too. So I'm so happy right now. Unhung Hero, thanks for the $5 super chat. More. Shush, you This has nothing to do with him. This is Georgia and a linebacker, a defensive player. I can't remember right now. Named Damon Wilson, who transferred from UGA to Missouri, and one of Georgia's collectives was like, hey, you broke the contract. We want our money back. So he has responded. He had responded back in December, but between Life, 2 Channels, and all the other drama going on in the world, this kind of took a back seat, so we have to get back to it. However, this is 127 pages, so we are not reading it word for word because ain't nobody got time for that, and nobody has the attention span for that, including your girl. And Unknown Hero, thanks for the 10 gifted Squid Pro Quo memberships. I appreciate you. So, yeah. Government ruins a lot of shit. Like, let's put it that way. For those unsure, I can attest to the fact that the real Heather is able to help those that need extra help with moving. Yes, Devil Fan is amazing for a testimonial, and I'm glad that he's sharing his story and a testimonial because I appreciate it very, very much. Alrighty, let's get into this. So as we all know and we've seen, Georgia does not allow me to purchase or to download the documents unless I purchase them, but I can look at them for free. So this was, what's interesting, does anybody happen to remember the name of the judge in the Edric Faust case? Because I think this is the same judge. Interestingly enough, now that I'm actually looking at the now that I'm actually looking at it, I think this is the same judge as the same judge as Edric Faust, which is totally kind of weird and interesting, but now that we understand who yeah, this is the same judge. I'm looking up Edric Faust case, and it's the same judge. All right, so this is the exact same judge. Bye. Hi, Tammy. Bye, Tammy. Have a good day. All right. Same judge as Edric Faust. So if you've watched any of the Edric Faust coverage, either on this channel over with Flash Fan or currently doing the rewatch with Mo in the Deep End, this we know this judge, so it's interesting. I believe she's a little bit. I don't like her. Let's put it that way. I'm not a fan. All right. So this is Damon Wilson II's answer. Affirmative defenses and cross application to stay arbitration. And just knowing what's going on in that, they basically asked for arbitration because arbitration was in the contract. He signed a contract, he transferred about 30 days later, and they want their money back. Jeffrey, way to be. Same personality. You gotta be biologically specific, don't you? All right. Wilson responds below to the numbered paragraphs in UGA's application, but he does not assume any obligation to respond to the arguments or other narrative material contained in any unnumbered paragraphs or headings of UGA's application. He denies any allegations, averments, characterizations, or suggestion in UGA's, and I'm just going to call this UGA because UGAA is University of Georgia Athletic Association. Applications that are met specifically admitted below. And this is where it's like, I hate when people do this because when they just do admitted, it's like you got to compare the first document with the second, and it's like, y'all, ain't nobody got time for that. Well, this particular contract, he signed 30 days before he transferred. So, I believe there was upfront money in the form of $130,000. Alright, paragraph 3 consists of legal conclusions or statutory recitations for which no response is required. To the extent a response is deemed, Wilson denies the allegations in paragraph 3. This is so stupid when Bruce did this shit too. Like, I hate when you have to compare 2 documents because I really don't want to compare 2 damn documents. It's no fun. You want chocolate? No, baby, you didn't eat lunch. Hold your earphones. Yeah, and we haven't even gotten into the legislation that is the SCORE Act, among other things. Like, then that's a whole topic in itself. That's a whole topic in itself. There's positives and negatives to it. Congress getting involved in anything is never a good thing in my opinion because the government always F shit up. At the end of the day, whenever Congress touches, turns to shit. Just you know. However, this has gotten so wild west because after the Supreme Court saying, yeah, you have to pay players, even though most colleges, SEC, I'm not looking directly at you, but if you know, you know, Alabama, Nick Saban, just to say, just not accusing anybody, but I'm just saying. When they handed down their ruling, it kind of became the wild west, and there are no rules. And it's pay to play. And I understand paying players for their names because these colleges are making millions of dollars off these players' names. However, there's got to be some limits in place. Hey, Jeff, I have to watch after the stream, do an appointment. Have a great stream, Squid and chat. Good luck. Please let me know if you need anything. And Jeff, thank you for the $150 Ko-fi. You have made my day as usual. You are yeah, you are an amazing human being. And I wish you the best. Just like allowing pros in the Olympics has ruined Olympic hockey and basketball. I don't really, the thing about it is for hockey, I don't watch men's Olympic hockey. I watch women's Olympic hockey. I watch the NHL on the regular most of the time. However, I find myself watching women's hockey in the Olympics because it is far more entertaining than the men. And I don't really ever say that about women's sports because generally women's sports bore the shit out of me. WNBA being the prime example. But I mean, women's hockey is freaking entertaining. And a lot of those players from all over the world went to Big Ten schools, which is rather interesting. There was a women's hockey is unreal. Yeah, there was a player from I think Sweden this morning that went to Ohio State. The USA women better get their butts in gear. Yeah, I think it's USA versus Canada. I've never seen a women's US team look like this, but I've also never seen a women's Canadian team look like this. So, and then the men are just the men. I don't know. I don't really know how to it's not a fault to the men. They're just like women. I think the reason why people watch the NHL is the physicality. And because you can't have that physicality in Olympics, and also NHL rink and an Olympic rink are different sizes. They're 3 feet or 4 feet different width-wise and lengthwise. Because I skated on Olympic ice at Pettit. The 2 hockey rinks in there were Olympic-size hockey rinks. So when I'd go to another rink and try to do my program or anything like that, and I'd run it and it's a smaller rink, it was freaky because I didn't have as much room. There's a definite size difference. And size matters. Yeah, it's always US versus Canada in women's hockey. Yeah. All right. Let's see. I'm just typing this in again to get the other document, because if he's going to do all this, paragraph 1, paragraph 2, it's so much easier if I just have the if I just have the other document up. So, yeah, women can be very interested in sports. We can get some kind of way and are more competitive. Yeah, women's hockey is always entertaining. Women's basketball, boring AF. Women's soccer, I think, is boring. Well, I think soccer is boring anyway, but that's neither here nor there. But women's hockey is entertaining as hell, and I love it. All right. Wilson admits that the collective paid him in December of 2024, denies that this payment was due under any agreement. In paragraph 8 is otherwise denied. So paragraph 8, and we're just going to detach these so we can kind of compare them side by side. It's so, like, it's so stupid sometimes. Okay, paragraph 8, the collective paid Wilson the first payment due under the agreement in December 2024. Wilson accepted the payment. So for him to literally say, Wilson admits the collective paid him, but it denies that this payment was due under any agreement, that's not what the contract said. Well, there's a difference between, like, playing and watching. Hockey, golf, for example. I used to love to golf. However, I cannot watch golf on TV. It is boring as hell. But, like, actually playing golf, I found very entertaining. So there's a difference between spectating and participating. I find golf very boring to watch, but so much fun to play. Admitted that Wilson provided the University of Georgia with written notice of his intent to transfer January 6th of 2025, that he withdrew from the school January 13th. Paragraph 9 is otherwise denied. So paragraph 9 was, he left the football team the day after he withdrew. It's so stupid. Admitted that CCC sent Wilson a letter demanding that he pay the collective $390,000, and that UGA's Exhibit B is true and accurate copy of that demand letter. Paragraph 10 is otherwise denied. The part that he's denying is, well, I don't know what he's denying in there, because it says, and demanded that he pay the liquidated damages. So he denied that he actually owes them? It's so weird. So it's so weird. Paragraph 12 consists of legal conclusions for which no response is required. But then why did you I hate when lawyers do this, because they're like, no response is required. But to the extent that the response is deemed necessary, you just said that it wasn't required. So yet here again, why are you talking about it? 12 was after the collective terminated the agreement and demanded payment of liquidated damages, as it assigned its rights under the agreement to UGA, including its rights not to pursue liquidated damages. Wilson lacks sufficient knowledge or information to form a belief as to the truth of any factual allegations. It's like he's just this is so stupid. It seems like he's trying to say it as a one-day contract. It's so stupid. Title, it was Volusia 1. It was Jeff Montgomery. Whee! I just got tagged in a whole bunch of response to UGA's requested relief contains no factual allegations requiring a response. Like this is like 127 pages of complete BS. I mean, the relief requested was appointing an arbitrator, compelling Wilson to submit arbitration as required under the agreement. The arbitration proceed as set forth in a Georgia statute, and for other such relief. It's just, and then they had the contract. Like, the court entered judgment in favor of respondent Wilson and deny applicant's UGA application to compel arbitration. What? UGA's application fails because the term sheet is not an enforceable contract. And this right here is where I think things need to change. He signed a contract, the term sheet. This is the term sheet. This is what we are talking about. I'm going to make this bigger so that everybody can see it. This is the term sheet that he is referring to. Term sheet providing full license option agreement set forth in the basic terms of the agreement between Damon Wilson and Classic City Collective. Although it's not a complete list of all contracted terms, the below terms will be used to create a legally binding document set forth all necessary contractual provisions. So this was monthly licensing fee, $30,000 per month as a freaking college kid. That to me is an outrageous number. Like, UGA's application fails because the term sheet's 5-word arbitration term is not valid or an enforceable arbitration agreement under Georgia statute 9-9-6B1. Like, So this is the term sheet. So this was termination. And CCC may immediately terminate the agreement if materially breaches this agreement, or licensor, Damon Wilson, fails to enroll and remain enrolled at UGA for the first semester session that licensor is eligible to enroll, or fails to enroll and remain enrolled in each subsequent semester session through the rest of the term. Withdraws from the UGA sports team. That right there, this whole section right here is like, there's your contract. So my thought is this right here will decide if NIL contracts are legally binding. I don't know what else to. This is one of those situations where college football has gone completely and totally off the rails. And yeah, I guarantee they're going to say there was no term limit on the contract. Well, here's the thing. May immediately terminate if like that paragraph right there, and number 2, fails to enroll or remain enrolled. He withdrew. Like, this is going to be this is going to be a big thing in college football. And I'm surprised that more people are not talking about this, because this is huge. You see a lot of people talking about Congress stepping in, but you don't see a lot of people talk about the actual lawsuits that are currently going on in jurisdictions all over the country. There's cases in Arkansas. There's this case. I'm personally talking about this case because I'm a UGA fan, and this case is like in my backyard. I was held to my student loan and that was 17. Well, see, and that's a little different but that's different because that's a legally these are new. Like there's no rules to these. Unfortunately, the rules to a student loan kind of suck. And you can take out um hundreds and hundreds of thousands of dollars of loans before you have any idea what an interest rate actually means. But with that being said, this is like a free agent contract. And think of NFL and free agency. That's what this reminds me of. Yes, but this is where it's going to be. This is new territory. A student loan has kind of been around and is enforceable based on federal statutes. This is all within the last 3 to 4 years. This is brand new territory. So there's not a lot of precedent about there's not a lot of case law about what these mean and what this is. So I see what you mean, but I still think it's different because of the fact that this is between a school and a person. I do like the way I do like the way UGA sometimes does it. Like if you go to UGA's football website and you go to purchase a player's jersey, the player will get a portion of their jersey sales. I think that is awesome because you're buying their jersey, so they should get the money. This and boosters stepping in, starting collectives, and this is just weird. I understand where you're coming from, but this is where talking to what's his name? Legal Mindset, because he works in contract law, or at least he used to, about what this actually means, because this is new territory. Yes, I understand Devil Fan, you and I could go back on this, but I think we have a miscommunication here because I understand where you're coming from, but because this is new territory, and yes, these are contracts, but these are contracts that have never had to stand up to a law before. So there's no statutes governing what NIL, there's no law governing what NIL contracts need to be, what they need to look like. Whereas student loans have been around for as long as I can remember. There are statutes, federal statutes, state statutes governing how much you can take out. Certain degrees you're capped at certain amounts. There is yes, it's kind of out of control, the spending and the borrowing, but there are limits and there are regulations. There are no regulations on this. That's the crazy part, and that's where I'm not sure from a contract law perspective what actually holds water. Because there are no federal regulations on anything NIL right now. It's literally the wild, wild west. There's not a damn law. States have tried, but you transfer schools to go to a different state and it's a whole new set of laws. Which is one of the reasons that, as much as I hate Congress stepping in, I think Congress needs to step in. That's the hard part. So, and I understand the comparing the two, but this is new territory, and I don't think anybody really knows what is going on with this. So, and that is true. Men's football, even no offense to basketball, but Basketball doesn't even get the revenue and the viewership that football does. Football is the moneymaker. However, we have to put limits on it, but what's appropriate? I don't know what the right answer is. UGA's application fails because the term sheet is contrary to public policy, but yet he never names the policy. That's where it's like, what? UGA's application fails due to a mutual mistake with respect to the non-binding preliminary term sheet. They keep bringing up the preliminary term sheet, but they forget that there is this. I'm going through the depends on the school. UTEP and New Mexico State make more from basketball than football. Yeah, I guess I'm from Big Ten and SEC territory, so football reigns supreme. So it's just UGA's application fails because UGA lacks standing to enforce the term sheet. But you signed the term sheet. Go on. Be right back. Mama duties. 30 seconds. Hey Chris, how are you? It's this is going to be an interesting one. Respondent Wilson's cross application to stay arbitration. In further response to UGA's application, Wilson brings this cross application to stay arbitration pursuant to that Georgia statute of the Georgia Arbitration Code provides that when a party files an application to compel arbitration, if a substantial issue concerning the validity of the agreement to substitute arbitration or compliance therewith is raised, then the court may deny the application for an order to arbitrate. So dumb. Just go to arbitration. Like, he's going to lose big time, and he's going to be lucky if the NCAA doesn't take a year of his eligibility away. Yeah. It's almost like he did this shit on purpose. I feel like he did this shit on purpose. I just have this, this sneaking suspicion, because you don't sign a contract and then transfer a month later. You know you're going to transfer or planning to transfer months in advance. Months in advance. Like, it's not something new. The one thing I know for sure is that lawyers will make money making this new precedent. They don't care about the kid. Yeah. Her baby girl's pad died when she was on the potty, so I gotta go get it. Be right back. Mama duties. Let's see.
Streaming live from the corner glow. Camera on, but the pace is slow. Little hands tugging at my sleeve. deep sigh. I hit pause, no need to ask why. Mama's on pause just for a while. Grab a drink, hold that smile. Bathroom break, life in a Sadie's. Be right back. My daughter needs. Chats alive, the comments roll. The tiny footsteps steal the goal. Toys scatter like a masterpiece. Mama duties never.
Hey guys, the little is right here. You want to say hi?
No.
Okay, maybe not. uh. Oh my goodness. I don't think the school he transferred to could pay him. He transferred to Missouri. Missouri's SEC too. Sort of. That's a discussion for another day. If you know, you know. It's just, yeah. That section further provides, in relevant part, a party who's not participated in the arbitration and who has not made the application to compel arbitration may apply to stay arbitration on the ground that no valid agreement to submit arbitration was made. Dude, you signed the sheet. The agreement to arbitrate was not complied with, or the arbitration is barred by limitation of time. To be clear, there is no pending arbitration. UGA did not attach any valid demand for arbitration to its application. And Wilson is unaware of any attempt by UGAA to initiate arbitration before any arbitral forum, let alone serve a demand for arbitration pending in any such forum. Instead, UGAA sent Wilson a letter that purports to demand arbitration, but that letter does not trigger such any statutory obligation on Wilson to seek a stay of arbitration. There is no arbitration to stay. After all, Section 996C requires that a party serve upon another party demand for arbitration. That is a demand for arbitration filed with an arbitration firm to initiate arbitration. How many times do you think we can say arbitration in one paragraph? Go get your Teddy Graham. No, go get Teddy Graham. You can have Teddy Grahams, but no, you can have candy. Girl, lungs are healthy. Can you please repeat that word again? Huh? I mean, sorry. Just let's get bubbles out. Let's just not. Let's just not. People are playing a dangerous game these days. All right. The plain text reading is reinforced by this section, which provides that demand for arbitration may be amended by either party to include disputes arising under the same agreement after the original demand is served. Oh my goodness. Is the arbitration moot if they moot the arbitration? Say arbitration one more mother effing time. Jeez. Damn, she hit my mute button when she was messing with my mic. Damn. Boomered it up. This mic has a mute button right here. And I look at the mute, it doesn't change the mute on StreamYard. So if she touches it and it mutes me, I can't tell. So basically, he was offered, a UGA employee approached several of the teammates and told them to go upstairs and presented them with these term sheets. They didn't have to sign them. And this is where being young and stupid comes into play. Because if the little comes within a foot of that mic, it triggers. No, she likes to mess with buttons because we're still in that button pushing stage. And yeah. And she touches it, but I don't realize that she touches it because it just turns this light red. But when I'm talking and looking at the screen, I can't see that. So I actually have to be out here in order to see that light. So, yeah. Once upstairs, Wilson was presented with the term sheet, which was already signed by the co-founder, Matt Hibbs. The term sheet contained a non-binding and expressly incomplete list of key terms that, if agreed to, would be used to create a legally binding contract. The team sheet states that it precedes a full license and option agreement. Example B2 specifically provides, in the event the parties agree to the term sheet, then shall work cooperatively to set forth these terms in a full legal contract, including all the standard provisions of NIL licensing agreements. And this is where being versed in contract law would be very helpful. Yes, it's a term sheet, but he signed it. And they paid him. And then he transferred. This will set precedent either way. Because if this is true and that term sheet doesn't hold water, but he signed it. Y'all, shut up. Shush. So I sort of agree with where they're going with this. However, the term sheet was still signed. Because remember, like this is I'm trying to get back to the term sheet here. So this is the term sheet. So, and it says termination, and he signs it right here. Like he signed it. So I'm torn because it might not be what they were going to set out as the full contract, but it is. It's just he signed this, the confidentiality without limiting other legal remedies to available party. Breach of this sanction may result in suspension or termination of the agreement. He signed that too. They literally have no excuse. It's all legal word salad to hide the fact that he took the money. And I get that. I'm torn not from an ethical standpoint. Like you signed something and you took money and then you transferred. From an ethical standpoint, I know where I stand on this. Give the money back. From a legal standpoint, and this is where what's legally right and morally and ethically right can be two different things. that is where I am torn because I am not a lawyer. I just like to read this stuff because I don't like headlines because headlines lie. Headlines try to lead you to thinking a certain way based on what the writer feels. And I hate that. It had a line he was supposed to sign. He did. It's right here. So this part that's highlighted in yellow, even though it's covered up by not an authorized copy, he signed it, dated it, and put his date of birth. So it was his signature, 12/2/24. 12, I think that's 12, yeah, 12/2/24. They love to sign stuff, don't they? I don't know. And this is where I'm like, this is where I'm so, you know, and for some reason, my mic keeps saying that it's unplugged. So I'm going to unplug it and plug it back in. I keep getting like an error from, there you go. Do you think he was confused or he really know what he was doing? Well, based on what he said over here, him and a bunch of teammates were brought upstairs. Once upstairs, Wilson was presented with the term sheet. I don't see why, which was already signed by the CEO and co-founder. I don't think that needs to be I'm going to time you out for like 30 seconds just because. Like, but I don't, that's where it's like, he was born in 2005. So he was what, 19 at the time of signing this? And that's from a college football perspective and signing all these contracts. These are just kids. And remember, our high schools in this country suck at teaching financial literacy. They suck at teaching literacy in general. But financial literacy is not something that we are well versed in as a high school student. So now you get these players who are paid lots and lots of money who are not financially literate, who also, no offense to football players, y'all have egos, because you think you're more important because you're good at a sport. Okay, I get 19 is a legal adult. I get it. However, 19 is still a kid. You don't have any life experience, and now you're being paid $30,000 a month to play a game. And we don't do a very good job at teaching kids, high school kids, financial literacy. So at 19, I had just graduated from high school. Like, I graduated from high school in June and turned 19 in September. So, like, yeah, I was an adult, but I had no life experience at 19. I wonder if he signed it and they're trying to claim it didn't have a real contract. I get that, but that's a little bit different than going and playing college football. I get that, Roy, because 19 was the day after my 19th birthday was the day after I graduated from basic. I get it. There's a level, but I still had no life experience at 19. So, and playing college football is an experience, but you're pampered, especially when you go to UGA. Have you seen UGA's football facilities? These kids get the royal treatment. This is not your typical 19-year-old. However, at the end of the day, our brains don't fully develop until 25. Roy, I'm sure at 19 you were not being handed a check for $30,000. You were not deposited, let's see, $390,000 into your liquidated damages. $390,000 is what they want. But he was paid, I think 30 grand. So there's a slight, and ma'am. So there's just a slight difference between then, even 2004, 2005, when I was 19, and now. I don't think he knew what he signed. I think he knew what he signed. I just didn't think that he thought that he would ever be held accountable. I know you didn't just hit me. One of these days you're going to run into somebody who's going to hit you back. No. Well, try that in school. Hit another kid, see what happens. Well, you have to have a brain in order for it to develop. They got you for $5,000. Yeah. Well, damages were $390,000. Yeah, I heard a rumor that they're trying to threaten certain things, and it's like, I've never in my life really wanted someone to fuck around and find out, but I have a lot of anger to get rid of. So oh, she's being what? I'm being what? Or me or her? So just over a week after Wilson hit the transfer portal in an undated letter, this collective sent him a purported termination notice that claimed to terminate the term sheet. The notice purported to exercise CCC's right to immediately terminate the term sheet based on Wilson having provided written notice of transfer. It also contained an invoice demanding Wilson pay $390,000 within 30 days. What? It's on the floor. You dropped it. Oh, thanks, Snipe, for the game updates. Here. There you go. You want to call Grandpa? Okay. Gotta go that way, though. No, you're fine. You're fine. I probably won't have the time to sit and watch it anyway, so I'll probably just hit the highlight sheet. So UGA since claimed that it owns all of the collective rights under the term sheet pursuant to an assignment agreement. Their claim, Wilson submit to arbitration that Wilson resolve their claim. Wilson owes UGA $390,000. Oh my goodness. So the footnote, unhappy with Wilson's decision to transfer, UGA also launched a coordinated campaign to punish Wilson by interfering with his ability to transfer and preventing him from realizing the benefits of free and open competition for his athletic services. Sweet Jesus. And the right to license his name, image, and likeness. That conduct by UGA is the subject of an action filed by Wilson in the Circuit Court of Boone County, Missouri. Yeah. You're welcome. Ooh, guess what? We got another lawsuit. Attached is Exhibit A. Oh, I'm writing this down. Wilson v. UGA. I don't know how Missouri is with their documents, but we're going to find out. 25 BA. Avery. Oh my goodness. So we have another case. Let's just go back to full ride scholarships and getting a free degree, no student loan debt. The degree will pay in the long run if chosen wisely. Yeah, here's the thing. I think we're long past that. I gotta turn off the little pad because I'm sick of hearing Mario. Angel. Okay. She called him. She called him and then handed me the phone. That's what she does. She calls and then hands me the phone. You're activating the Baby Squid Orthodontic Fund. Oh, yeah, we're going to need braces in the future, not now. And Harry, thanks for the $5 super chat for the little squid for some candy. Thanks. She's mad at me right now because I won't let her have candy because she hasn't eaten lunch. She didn't want to eat the lunch that I made for her, so she doesn't get candy. You know, I'm not a perfect mom by any stretch of the imagination. However, I try to enable basic rules for life. No candy before dinner. Yeah, they just need to outline how the athletes get paid. It needs to be standardized, and it's not even close. Not even close. So okay. Okay. Performance bonuses would be nice. I just think the collectives suck. The outside influences, you get boosters because that right there, I feel totally my opinion, does not reflect the opinion of any college or team I root for. However, personally, my opinion, and may not actually be accurate, I just think that when you have outside influences, collectives, the teams with the highest paid boosters, like if you get a school is good with business, a school has a good business college. Well, a lot of those graduates make a lot of money in finance. They have a lot of money to put into collectives and paying players. Whereas like Jones Community College in BFE, Georgia, doesn't have boosters that will put money into their... It's the outside influences that I can't stand. If it were the college itself, I'm a little less opposed to that because it's the actual college. But it's the outside, it's all these boosters, like the Rashada V. Unhung Hero, if you're still watching, HATH, Hath, Hugh Hathcock. That collective out of Florida wanting to pay a player $13 million. Huh? The collectives need to go away. Crazy idea. Maybe the schools should use the money that they make to educate students better, not pay millions for coaches and training facilities, instead physics and engineering departments. That's a really good point too. I don't disagree with that. Maybe take some of the money that you earn and use it to lower your damn tuition. Why are we paying $10,000 a year in tuition when you're paying your football coach $13 million? 11 million. Kirby's being paid $11 million. Kirby is like the highest. Kirby Smart, Georgia's coach, is the highest paid coach in college football. And part of his contract, I believe, is that he gets a raise anytime a coach gets paid more than him. So anytime say Alabama hires somebody and they pay $11.5 million, well, now Kirby gets a raise. I haven't actually seen his contract to know that for sure, but that's the rumor. Yeah. Only because he super chatted me would I say it. Every scholarship athlete is paid in education, housing, food, books, and tutoring. And I understand that. And I do think that there needs to be when colleges are making millions of dollars on these kids' names in media rights and all of that, I think that the players do need to be paid. However, I think there needs to be limits, because this right here is outrageous. $30,000 a month as a 19-year-old, you don't have the financial literacy. That's when you start paying more attention to the money than your school. Yeah, hundreds of millions. You could easily put some of that money you're making back into lowering the cost of your tuition. And just, or lowering the cost of your ticket sales. Because when it costs $1,000 to go watch a football game, I don't want to freaking go. 99% of college athletes, you would never know their name. Imagine two coaches with that in their contract. He's getting more than me, so I get a raise. Now they're getting more than me, so I'm getting, exactly. UGA cannot compel arbitration because the term sheet is a non-binding set of terms to be used in creating a legally binding agreement, not a contract. This is where I'm torn. So I'm interested to see what they say. The term sheet they seek to enforce a set of non-binding terms to be used as to create a legally binding document. Not a binding contract to license Wilson's NIL rights, so UGA's application should be denied and any arbitration should be stayed. Arbitration in Georgia is a matter of contract. As such, the contract of such an arbitration clause in a contract is subject to the ordinary rules of contract construction. This case law, citations, alterations, and quotations omitted. Term sheet providing that the parties will later enter into a binding agreement. Contract contains certain provisions is not a contract. That right there. No contract under Georgia law where term sheet anticipated additional future agreements and was tentative and incomplete. Term sheet, not a contract because it contained only aspirational language and was missing definite and certain terms regarding obligations owed. Letter of intent that twice stated it was subject to a definite agreement was not an enforceable contract. And there we go. Once again, a difference between what is morally and ethically right. You took the money, pay the money back. And what is legally right. He never signed a contract and they paid him anyway. There's where it gets complicated, and that's one of the loopholes that I feel needs to be closed up. A college athlete should not be able to accept money unless they have a contract, not a term sheet, a contract. And here's the thing, does the NCAA, because they only had a term sheet and not a contract, could the player get in trouble and the school get in trouble with the NCAA for paying a player without a contract? There's another what if that I don't know the answer to. I just, what do they think a legally binding agreement is? Well, if you look at the actual fact or term sheet, it does say, and this is where I just read these things and call balls and strikes as we see it. let's see. In the event that the parties agree to this term sheet, then they shall work cooperatively to set forth these terms in a full legal contract, including all standard provisions of NIL licensing agreements. Does that phrase right there mean that it wasn't legally binding? However, he signed it. It's so he would have been paid any money up until now. Well, he wouldn't if he shouldn't have been paid, because he should not have been paid. This is my opinion, not based on what I'm reading. I think Damon Wilson has a point. I don't necessarily agree with it from an ethical standpoint, but it's a very interesting concept. And this is where the judge will have to be like, does the term sheet, because it's signed. That's a thing right there. Because it's signed. I've had term sheets before. Like, you get an application for a credit card. There's a term sheet attached to it. But it's not signed by anybody, so it's not a legally binding thing. Because it's just, hey, if you apply for this is going to be the terms of your application. You know what I mean? The fine print. However, this term sheet is signed. That puts a little, like, if I were to just Google term sheet, term sheet template. Let's see, images. So this is what I did, because I'm just looking at it. We're just going to click on one and we're just going to see. None of these things have a place where you can sign. And like I said, this is just me, this is how my brain works. The term sheet, view page. If I were to look at this, it's not letting me look at them, but I just want to see the back page, because if the back page doesn't have a signature line, and I don't want to download anything. I really don't want to download anything. Oh, fine. And no, we're not downloading extensions, because good Lord. All right. I downloaded this one. Well, we're just going to see if a basic template has, to confirm your acceptance of this term sheet, please sign and date the duplicate of this term sheet and return it to me. So, term sheet has a signing or a signature line on it. Interesting. This is where I would love to talk to Legal Mindset. I don't think he'd ever talk to me. I'm too small of a channel, but I think that he would be interesting to talk to. Well, that was a free download. This download costs money. If I added this document to my cart right now, let's see. Add entire document to your cart to purchase. We're going to see how much this document would cost me. Come on. Maybe. Let's see. My cart. $63.50. Like right there. Y'all can see. Total purchases $63.50. I'm not purchasing this document. This is why we do it on the computer, and it's a little bit harder because I can't highlight things. But like, I am not well, yeah, because you've actually signed the application. That's the you've signed the app, and that's why I don't buy documents from Georgia, because even Pacer, that would only be a $3 document. $6 tops, because the exhibits can be seen as different documents. So $6 tops. $63 for that document. Like, it's just like going through this whole thing. Even if the term sheet was a valid contract, the arbitration term is not a valid agreement to submit to arbitration. I mean, here, even on its own terms, a term sheet's arbitration term is not an arbitration agreement. The entirety of this purported arbitration agreement reads subject to mandatory arbitration clause, and UGA concedes no other language in the term sheet addresses dispute resolution. This is, at bottom, the parties did not agree to arbitrate any dispute by signing the term sheet. The parties never negotiated a mandatory arbitration clause, much less agreed to one. So there's no arbitration agreement for this court or any other to enforce. Unpopular opinion, I think that this lawyer has a point. I don't like it. And once again, this is where y'all kind of argue with me sometimes of like, well, this. Stop thinking emotionally and start thinking legally. I don't think things are morally and ethically right, but sometimes just because they're more like, just because something is more against my morals and ethics, him taking the money without a contract and then transferring, completely unethical and shitty behavior from that kid. However, not against the terms of any contract because he didn't sign one. Was this written? No, this was much better than any document written by that dude. Like, this is actually not a bad document. I know y'all don't have to like it. But remember, just because you don't like something doesn't mean you're right. Just because it makes you emotional doesn't make you right. Just because it makes you morally outraged doesn't make you right. And that right there is where we tend to go wrong as a society. We think that, oh, it's against our morals or it's unethical. Therefore, he needs to pay back the money, or he needs it. Well, according to the law in Georgia, if they cited everything correctly, that's not entirely accurate. So just because it makes you angry doesn't make you right. And UGA failed. Oh, we're going to go back to the beginning. If I take too much time, it restarts. So once again, just because, like, it's my phrase for life, just because you are morally outraged by something and you think it's unethical doesn't make you correct. Put it that way. Yes, and I understand it's a big if, but because according to the case law that this lawyer cited, a term sheet is not a binding contract. You might not like it. You might not like it. Right here, UGA cannot compel arbitration because the term sheet is a non-binding set of terms used in creating a legally binding agreement, not a contract. All this case law, term sheet is not a contract because it contained only aspirational language and was missing definite and certain terms regarding obligations owed. Letter of intent that twice stated to a definite agreement was not an enforceable contract. On its face, the term sheet is just that, a preliminary list of terms to be used by the parties working cooperatively to attempt to reach a full and binding NIL agreement. In fact, the term sheet expressly precedes a full license and option agreement and provides that its terms will be used to create a legally binding document, set forth all necessary contractual provisions. There's the, I understand what you're saying, but you have to think, you are thinking with a morality clause, with a sense of morals, not the legal, like down to the language. According to the case law cited, if cited correctly, is a term sheet is not a legally binding contract. If that holds true, then this guy's got a point. Like, since our last election, I've learned a whole new definition of morally correct. And that's the thing. But it's similar to credit cards too. Well, credit cards, you sign a contract. You sign an application. When you apply, that is a legally binding contract. Your credit card application. Because when you sign it, you say, I see all these things to be true to the best of my knowledge, blah, 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 whatever. But that is your legally binding contract. A term sheet, according to what has been cited here, is not a contract. It's legally binding once the card issues you. Yeah, well, here's the thing. I get that, but that's a credit card. That is not a term sheet in a NIL contract. And once again, we're thinking from a moral standpoint and not an ethical. I think that he never should have signed it. I think from an ethical standpoint, you put your name on something and you accepted money. But from Georgia law, if these cases are cited correctly, a term sheet, I don't know how many, like, Devil Fan, I love you, but I don't know how many times I could sit here and say the same thing over and over again. It's like a term sheet, according to what has been cited, is not a legally binding contract. Well, and once again, this is not a credit card. This is an NIL contract. But I'm not repeating myself once again because I've literally said the same thing. It's clear as mud, but it's still clear. Yeah. Like, it's just, like, I don't know how, like, I can't say it any other way. Like, I literally can't say it any other way. I don't think they closed that loophole. Not if you look at the term sheet in this other document, that is not illegally, if this case law was cited correctly, no matter what way, what spin and how many ways you want to try to decipher it and spin it to make it seem like it fits your narrative. If that case law was cited correctly, because of this phrase right here, in the event the parties agree to this term sheet, then they shall work cooperatively to set forth these terms in a full legal contract, including the standard provisions of NIL licensing agreements. That phrase right there puts this as his contract will be subject to mandatory arbitration contract. Clause. His contract will be subject to liquidated damages if CCC terminates the agreement. His contract will be subject to termination if he withdraws from the school. Like, it's if you agree to these terms, these will be the terms of your contract. yeah, it's so if you put it in a legal contract can be verbal, oral, implied by conduct, and all three are enforceable if they can sell essential elements of an offer, acceptance, and consideration. While written contracts provide the clearest evidence, verbal agreements are legally binding. Applied contracts formed through actions and reasonable expectations. And that is that's going to be one of how the judge interprets this based on past case law. Because that phrase right here, in the event the parties agree to this term sheet, then they shall work cooperatively to set forth these terms in a full legal contract, which implies that this is not a full legal contract. It's all about the past precedent, the case law, and what the judge interprets. But it's so this was his lawsuit against the University of Georgia, which we will get to at another time. I'm going to see if I can get it where I can download it. Because this is ridiculous. It's getting to the point where it's like, yeah. The court further possesses jurisdiction to hear Wilson's claims for tortious interference with contract and business expectancy, civil conspiracy, breach of contract, and defamation. What does that sound like? What does that sound like? So it's going to be interesting, because this is he gets into the court's decisions with NIL. Yeah, it's following the settlement in college athletes NIL litigation, Northern District of California, the House settlement, which went into effect July 1st of 2025. Universities may now for the first time enter directly into NIL agreements to provide financial benefits to student athletes. So this gets into more of that, and we will get into it later. I'm going to see if there's anything more in this that I'm going to see about any more that gets into what UGA, and then we'll read his lawsuit against UGA separately. It's agreeing to agree to a contract. Yeah, it's tortious interference with contract and business expectancy. Civil conspiracy. Angel Bug answered phone. It's, Exhibit B. Here's the term sheet. This term sheet, preceding full license and option agreement, we kind of went over this. He puts it, you can see it a little bit better. It's a little bit bigger, but not an authorized copy is still right over it. Exhibit C, assignment agreement. Assignment agreement between Classic City Collective and the UGAA. CCC entered in a NIL license agreements with UGA student athletes. Hold on, baby. Oh, no. There you go. There you go. Torturous interference or tortious interference? I mean, it seems like torture at this point. Like mental torture. We decided that we need a sugar daddy to pay for these document downloads. Anyone interested? Angel Bug, what's that? You want to call on this one? All right. Oh my goodness. Oh, shoot. And this is still only halfway through. And he's just repeating what we read through in the other. He puts the term sheet again. He's just repeating what was in UGA's motion for arbitration. And I know I'm going to get hate from this. So, you know, both the... let me just take this down for a second because I just want to make sure that there's not So there was a Boone County, Missouri Sheriff's Department deputy who attempted to serve him. You might also pick up your documents at Boone County Sheriff's, like, to arrange delivery of important court documents. I just really wanted to make sure that I didn't get we didn't get booted. So, like, here's the summons. This is the application to compel arbitration, which is, he basically just copied and pasted, well, attached everything that UGA had in their motion. So his motion is pretty much done. We've already gone through all this before. You know, I'm just, this is where things get complicated because I don't necessarily agree with the fact that he took money. I really don't agree with the fact that he took money. He accepted a payment when he didn't have a contract. That screams shady from both sides. But that, and this is the thing, the term sheet may not be a legally binding contract because of some of the things that were said in there and some of the case law. However, UGA and their lawyers might have thought it was, and that's the thing, be careful who you hire as a lawyer. UGA, if you lose this, you should really look at who your in-house counsel is and who is counsel for these collectives coming to talk to these kids, because y'all got to do better. From a college football fan perspective, and someone who likes reading legal documents but hates the government, if that makes any sense, I lead a complicated life. Y'all got to do better. But should kids be earning $30,000 a month to play football? Do they have the financial literacy? And are they mature enough to handle that kind of money in addition to all the other pressures that we put on college athletes? It's an interesting thought process. I don't really know what the right answer is, but this is why we discuss it. However, updates. There is a hearing on this case that was requested by Georgia. And they have a response and opposition that I'm just not going to get into because it's another, it's just another long held, like, I'll get into it real quick. This has to be super fast though. So this is their response. They have a hearing on this March 4th. And although I can't drive my ass to Athens, Clark County to go listen to it, I will be watching and seeing what happens. Like, So respondent did not satisfy his obligations under the agreement. In fact, he did not even make it a month. Less than 3 weeks after signing the agreement and receiving the initial $30,000 payment due under it, respondent entered the transfer portal, transferred to the University of Missouri, thus breached the agreement. Well, that's the thing, is the agreement And the term sheet illegal. See, and that's the thing. That's where the question lies. Is the term sheet a legally binding contract? There's something outside. Is there a box? You can't have cake. That's Daddy's. There's a red velvet cupcake in the refrigerator. That is Mr. Squid's for his birthday. He still has not eaten it. And she wants it. And she can't have it because it does not belong to her. And she is not happy. Not happy. She had one. She had hers. Hers was chocolate. She had hers. That one is her father's. Does not belong to her. There was 4 of them. There was one for Mr. Squid, one for Baby Squid, one for me, and one for Mama Squid. The only one left is the one for Mr. Squid, and she cannot have it, and she is not happy. She is not happy. Like, she's not happy. So she keeps coming to me and yelling at me because it's in the fridge, and it's where she can't reach it. But she's not happy. And I've kind of been like, honey, are you going to eat it? He's like, yeah, I'm going to eat it. I'm like, you better eat it fast because your daughter's going to get to it before you do. The agreement, and here's what UGA says. The agreement is a binding contract. And this is where I believe, in my opinion, the fight will come down to. The agreement is a binding contract is shown by its definite terms and respondents' acceptance and retention of payment. That's the other thing. He accepted the payment. So it might, here's where my brain goes. Like I said, not a lawyer, just trying to critically think without a whole lot of bias. It might not be a term sheet in general, might not be a binding contract. However, once he receives the money and once he accepts the money, does it become a binding contract now? Yeah, the retention of payment is a big deal. That's where the question lies, and that's what I don't know. And that's why we talk about it, we discuss it. But I'm not a lawyer. I don't claim to know these things. This is just how my brain breaks shit down. The term sheet in itself, like he was saying, a term sheet in itself might not be a binding contract, but they bring up a good point. He received the payment. He accepted the payment. Does it now become a binding contract after you accept payment? And the case law he might have cited might have not included because it's not always about what they say, it's what they don't say. The case law included might not have included any language about accepting money. Remember that case cited from a U.S. appellate court where the term sheet was binding? I'm guessing UGA will argue under that premise. Oh, that's a really good, yeah. I expect to hear a loud crash any second. That's Baby Squid assaulting the fridge. Yeah, It's definitely something that, and which is one of the reasons that I like covering this stuff, because it makes you ask questions. And like, I don't claim to know all the answers. I just like asking questions and bringing these things up, because in a 3-minute article, you won't hear this. Or I love JD Patel from On3, but you will not hear him talking about NIL and the legal side of things, because that's just not his realm. I like the legal side of things, but I love sports. So I like when things that I know to be happening and I'm like, why is this happening? Now hit the legal world and I can be like, let's see what's going on behind the scenes and peel back the layers of the onion and see what's happening where no one wants you to look. That's where I like to look. I like to look at people's dirty little secrets and dirty laundry. It's fun. You never know what you find in the pocket of someone's jeans when they don't want you to look at their dirty laundry. Harry, thanks for the $20 super chat for Little Squid, a full cake. Thank you. Thank you. And for those of you who are wondering, she is back to feeling like herself. Her temperature is still, she has still a little bit of a low grade fever, like 99.2, but it's elevated for her, but she's obviously, you could see she's running around here like everything's good to go. U.S. Appellate Court says yes. In a lot of states, taking payment is a contract. And I think that's what UGA will argue. But I also think you can't have daddy's cake. Hold your ear. Like, this is in front of Judge Judy. I know what she would tell the player. I mean, Judge Squid is going with UGA because you accepted money. If you wouldn't have accepted money, I'd be like, yeah, it's a term sheet, not a binding agreement. Because of the clause at the bottom, if we agree to this, we will, negotiate a full contract. However, the accepting of the money, if they believe you're right, though, that wording in the contract is going to bite them. Yeah, yes, if the accepting of the payment is huge, though, and I failed to take that one into account when I was reading his side of things. It's the agreement is a binding contract by its express terms. It contains all the essential terms of a contract, parties able to contract, consideration, mutual assent, and definite subject matter. I mean, all of these terms are present here, and a signature. First, the respondent was. I just like was and is a competent adult. I would have kept my petty side. Would have just kept with the was. He was a competent adult. You ate the steak, pay for it. Yeah, you drank the fucking drink, now pay for it. Works too. Yeah. Oh, it's always about it's always about the money. It always comes back to money. That's why when it comes to money, like, I don't play. When it comes to money, it's like I appreciate when people give me their hard-earned money, but I'm also like not upset when I do a stream and I don't get any super chats. Is it disappointing? Slightly. I'm not gonna lie. It's always nice to get super chats. I'm not gonna lie. But I'm not like some people who will go, well, I didn't get enough super chats today. Blah, blah, blah. No, because it's not your money. Like, it's people's money that they choose to give to you because they like your content. It's just the agreement included consideration on both sides. The collective agreed to pay respondent $500,000 over 14 months. Oh my God. I can't imagine what that amount of money looks like. Like, you know what I mean? When you hear that someone half your age is making a level of money that you will never see in a 14-month period, I would love to make 6 figures in a 14-month period. He's making he was set to make 500, and that's only one NIL contract. That's not jersey sales. That's not anything else. It's one contract. I just can't. I just can't. Like, my brain can't process that amount of money. And respondent agreed to allow collective to use his name, image, and likeness. Third, both parties signed the agreement. Fourth, the agreement subject matter is definite and certain because it contains matter which will enable the courts, under proper rules of construction, to ascertain terms and conditions on which the parties intended to bind themselves. Here's the thing: intended to bind themselves. That word. No, I don't begrudge them making any amount. They do work hard to keep their body in that shape. Yes, I get that. It's just, ugh. True. Like I said, I'm not opposed to these players getting paid because of the college making millions of dollars off of them They should get something. Sometimes you look at a sum and you're like, oh, I'm going to clutch my pearls now because holy crap, someone half the age making a level of money that I will never see in my lifetime. Under the agreement, the collective agreed to pay respondent 14 monthly payments of $30,000 and 2 additional payments of $40,000 at specified times, and in return, the collective received an irrevocable, worldwide, royalty-free, fully paid up, transferable, and sub-licensed license to reproduce display exhibit published, name, image, and likeness for a period of December 2024 through January 2026. In his cross-application, respondent argues because the agreement is titled term sheet and contemplated the execution of a subsequent agreement, it does not bind the parties. He's wrong on both accounts. I mean, they didn't waste any language, both in contract cases and the law generally. Respondent is correct that the parties never entered into the full license and option agreement referenced in the agreement. But this is hardly surprising. Respondent entered the NCAA transfer portal less than 3 weeks after signing the agreement. The extent was a more formal contract was never entered because Robertson refused to do so. He is the party who breached the agreement to enter into a separate contract while continuing to accept the fruits of the letter agreement. Equity therefore prevents him from complaining that another agreement was never entered. I mean, I gotta give their legal team credit because they're not playing around here. In Robertson, 2 attorneys signed a letter and agreement to jointly represent a client. The letter agreement stated the scope of the work each attorney would perform, defined the percentages of fees each attorney would be entitled, and required one attorney to indemnify the other for any liability arising from the representation. And using language similar to the agreement here, the letter agreement also stated that once your firm has been properly engaged to represent the interests of the client, then we will enter into a more formal and binding agreement which set forth the parameters laid down in this letter. On appeal, the Court of Appeals rejected the very argument advanced by the respondent here. And that the letter's enforceability as a contract between the parties did not fail because the parties intended to enter a more formal binding agreement. Robertson is not an outlier. In the Cook Pecan Company, I know I'm going to get a hate for that. This word in the South, how you say pecan versus pecan, is a thing. The purchaser of a plot of land executed the following agreement with a pecan farming company. Although the parties never negotiated or signed another document, the Court of Appeals held the original agreement between them constituted a lease because it contained all the essential terms of the contract. It identified the parties' property and agreement's terms and the share of the proceeds. I'm just, it's one of those situations where you look at stuff and you're like, I see both sides. And it all comes down to what the judge thinks. I have pictures from her first birthday of her smash cake, and it was red velvet, so it was messy. I mean, UGA did not hold back in their response. The agreement's arbitration requirement need not separately initialed because it does not relate to the terms and conditions of employment. Respondent also argues agreement's arbitration clause is not enforceable because that statute requires arbitration clauses to related to terms and conditions of employment to be separately initialed. But the agreement is an intellectual property licensing contract, not an employment contract. I mean, hey, Foxy. And we're almost done, so it's, this will be an interesting hearing, to say the least. The Georgia Arbitration Code does not require demand for arbitration before applying to compel arbitration. When respondent ignored this demand, UGA applied to compel arbitration, but UGA was never required to serve a demand for arbitration in the first place, making any alleged defects in the demand immaterial to both UGA's application to compel arbitration and respondent's cross application to stay arbitration. I'm a carrot cake kind of person myself. Just to, it's sweet, but it's not overly sweet. So, respondent is not entitled to stay of arbitration. The parties entered a binding contract as shown by its definite terms, the parties' performance, and respondent's ongoing attempt to enforce a provision of the contract in Missouri court. Although the arbitration clause is short, the law requires only that it be in writing and show an intent to arbitrate, which it does. I mean, well, we shall see. And we will get into his lawsuit against UGA in a different stream, because I'm going to look up from Boone County, Missouri, and see if I can get that document separately and more documents rather than just going through this hot mess express again. So, I'm going to be making some carrot cake cupcakes soon. Love me some cream cheese frosting. I know, right? It's the best. It's the best. You can never go wrong. And plus, because it does have carrots in it, you're technically eating a vegetable. Technically speaking. All right, guys, that's all I got for you today. There is a hearing on this March 4th. I will kind of be updating from there to see where we go in this case. And I know I'm going to get hate in the comments because who is this girl who doesn't know what she's talking about with college football, who's not a lawyer, talking about this like I did last time? And I'm pretty sure that dude was just trying to get clicks on his page because he's not monetized, but he's so close. So I'm assuming he was just using my page to get rage views. But you know what? Y'all have a great day. I'm going to see if there's anywhere I can send y'all today, because I haven't redirected to anybody in a while, and I like to share the love. So, Mo in the Deep End is still doing a Petty Express speed run, which actually, pay attention. Go see her, Georgia v. Faust. This is the judge that is overseeing the case we just talked about. So go tell Mo I said hi and ask her what she thinks of this judge. Y'all have a great day, and I will see you guys on the next one. Bye.